Mr. Gomez, if you'd approach on unrelated matters. May not be your bailiwick, but
Mr. Jerice Williams here today. Today's case is 24 CF 1687. There are a number of other cases in violation status, but I believe those are already taken off when we filed our written denial. I believe we filed one in this case. And if not, or it was lost or some other problem, we would just enter a denial today and ask. They all track together. The violations are based on a new law that I don't believe is even populated in the clerk's site yet.
all right. So he was detained on other charges already before the new law came along?
I believe he was out on probation, Your Honor. There was a new law violation. I believe the violation report says he was arrested December 25th. It looks like we were retained late February, filed all of our pleadings.
But the new law is not on the clerk's website
I
yet?
believe it's a Walton County case.
Oh, is it Walton County?
It is.
I apologize, Your Honor. That's right. It was out of Walton County.
Okay. Do we know the status in Walton County?
It's a pretty serious allegation or charge, Your Honor, and
It is, Your Honor. I'm just checking to make sure we have filed in there as well.
it's one that'll probably take a minute to resolve.
That is correct, Your Honor.
All right.
And can the two of us approach briefly?
Yes, sir.
Thank you, Your Honor.
You're welcome. Anything further?
And no, Your Honor.
All right, very good. We don't remain set, no subs on 514.
Thank you very much. I believe that's all I have.
All right, thank you, Mr. Alden. Ms. Dudley? She's, I think, in front of Judge Clark. Ms. Jaquith?
Your Honor, I have Tammy Moore on the docket this morning. Ms. Moore is present and approaching in 23 CF 1607. Your Honor, we are here for a competency hearing review based on the, excuse me, Judge. The procedural posture of the case is that Ms. Moore was initially found incompetent to proceed in September 2024. At that time, she was referred to APD for competency training as well as additional evaluations to determine, really it was just an additional evaluation so the APD would essentially take her into into APD, which they did, and she has been doing the competency training for a little over a year. The court had ordered a reevaluation to determine, based on Mr. Sanchez from Lakeview's recommendation, to determine whether or not Ms. Moore was going to regain competency. We now have 2 doctors' reports, both stating that they do not believe that Ms. Moore will regain competency in the foreseeable future. And based on that, Judge, and based on the fact that she has been incompetent for about 18 months at this point, based on intellectual disability, we are moving the court to dismiss these charges without prejudice to the state to refile should she become competent in the future.
All right.
And I have a whole written out argument, Judge, but I did provide the case law to the court and the state previously, and I know that the court does its homework and reads that case law, so I will defer to the court at this point. I'm not sure what the state's position is going to be today, but my position is the only evidence before the court is that Ms. Moore is not restorable, and based on the case law, the only appropriate resolution at this point is non-conditional release and dismissal of the charges without prejudice to the state.
Your Honor, the state does not dispute the case law provided by defense and even the interpretation of it. The problem the state finds in the reports is that the state doesn't believe that they provide competent, substantial evidence that Ms. Moore is non-restorable. And the reason for saying this is because first of all, the evaluation provided by Dr. Klein on December 8, 2025 appears to be, for the most part, a cut and paste on the evaluation that he provided.
Well, but if that's the situation, then we'll need the expert to come and testify to that. I'm not going to accept arguments based upon the written report. If you're challenging the quality or value of the report, then that witness is going to have to testify and be subject to cross-examination, is the way I understand the prevailing law on that question. So we'll set it for an evidentiary hearing, and you'll subpoena the doctor to be present.
I will not subpoena the doctor, Judge. I don't believe there's any ambiguity in the reports. So if the state feels it necessary to subpoena the doctors, they can do so, but which I kind of thought was what we were here for today, and there were no subpoenas sent, so. But I don't have any concerns about ambiguity within the reports. Dr. Klein has been the evaluator for Ms. Moore since she began with APD. Considering Mr. Sanchez's assertion that Ms. Moore, despite her best effort and despite regular attendance as required, has not made any progress, I'm not really sure what else we're going to expect from Dr. Klein in a report other than the same information he previously gave us. But I guess if the state is moving to continue so they can subpoena the doctors, I mean, I would object because that's what we're here for today, and the state has had sufficient time to do so.
Well, if you'd approach.
And Judge, based on the conversation at the bench, we're resetting this to April 16th at 1:30,
2 o'clock.
2 o'clock.
2 o'clock. Thank you, Your Honor. It's a competency
Another
hearing.
competency hearing.
Madam Clerk, do you need me to file a notice of hearing? Okay. That's all I have before the court, if I may be excused.
Yes, ma'am.
Thank you, Your Honor.
All right. Ms. Dudley, is she back? Okay. We've got some folks in the courtroom. Yes.
And Judge, I have one that's time sensitive on Zoom.
Okay,
Mr. Noakes is also in Zoom, Your Honor. You want me to let the court know?
all right, thank you. Good morning, Mr. Noakes. We have one, I think, is that your case, the other connection, Mr. McKinney? Can't hear you, Mr. Noakes, you're on mute.
Hello?
Okay, sorry about that, Judge. I've got Jill Madonia.
Yes, sir. We've got one other we're going to take first that we have some, that we need to take care of first. So go ahead, Mr. McKinney.
Judge, I believe this is Tracy Woods. Miss Woods, is that you?
Yes, sir, I'm here.
Okay, can you hear us okay?
Yes, sir, I do.
Judge, this is Tracy Woods before the court in 23 CF 1668. She is currently in the Federal Bureau of Prisons on a separate case. And the intention here is the state has agreed to let her enter a plea to 2 lesser included misdemeanors. Is the court in a position to do that over Zoom without a written plea agreement since they're misdemeanors?
Yes, I am, if the state agrees.
That's the state agreement, we agree with.
And
Okay.
given her placement in the federal prison, this will clear the hold from Florida in 23 CF 1668. The state would take no action on the failure to appear in this matter. And Ms. Woods would be entering a plea to 2 lesser included offenses of possession of paraphernalia.
All right. And what are the terms and conditions?
And that, Madam Clerk, that would be 893, 147, sub 1. And I believe the agreement with the state is for an 1129 Okaloosa County Jail sentence, but stipulating that she has served that sentence, giving her placement in federal prison until 2027. So it's the intention that that sentence is completed with standard court costs.
That's the state's agreement.
All right. And those court costs would be, Madam Clerk?
$270 court costs, $150 public services.
All right. Ms. Woods, can you raise your right hand for me, please?
Yes, sir.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, you can put your hand down. Now, you're not in the state of Florida, right?
No, sir.
What
I'm
state?
in Texas.
In Texas. All right, do you,
I'm in Texas.
do you agree to accept this oath and be responsible for any violation of this oath, which could include charges of perjury or sanctions such as contempt in the state of Florida?
Yes, sir.
All right. Now, you heard what Mr. McKinney said just now regarding a plea to 2 lesser included offenses, misdemeanor offenses of possession of paraphernalia. Is that what you want to do today?
Yes, sir.
Do you understand that this plea would be a plea of no contest to those charges?
Yes, sir.
And by pleading no contest, what I understand you to say is that you believe the state has the evidence to convince the jury of your guilt of these charges, and you're not going to contest that.
Yes, sir.
And do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes, sir, absolutely.
Do you understand that you will be adjudicated guilty and you'll be sentenced to 11 months, 29 days in incarceration based upon this plea agreement?
Yes, sir.
And the state has stipulated that based upon your time of arrest and your current incarceration, that you have fully served that sentence at this time.
Yes, sir.
Has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir, absolutely. We spoke.
All right, and are you satisfied with how he's represented you?
Yes, sir, I am. Thank you.
I'll find the plea to be freely and voluntarily entered into, and I'll accept the plea, and I'll provide you a year after you're released from your present incarceration to get all your fees and costs paid, okay?
Absolutely, sir. Do you know what those costs would be?
It's the $270 for the fines and fees, and it's $150 for state-provided legal assistance.
Okay, thank you, sir.
Thank
And those
you now.
amounts are payable to the Okaloosa County Clerk of the Court.
Okay,
So when you're released and you start your federal probation, be sure you contact Okaloosa to get on a payment plan.
absolutely. Thank you so much.
Thank you now. Good day.
Thank you. Have a good day. Thank you so much.
Thank you.
All right, Mr. Nopes.
For your honors. I've got Miss Madonia, and she's asking that her bond be modified. She's actually got 2 case numbers, but I think she's primarily asking that 26 CF 209, the court consider modifying that downward.
All right. So we've got 25 CF 827. You say it's 2026 CF.
Right.
And what's the
209.
209?
Yes, sir.
Okay. All right, what's the state's position on the defense's bond motion?
The state would object to any modification. We were here, it appears exactly a month ago on 2/19 and had a bond hearing, and the court established $50,000 cash or professional on both counts in 26 CF 209 with pretrial services and some different conditions. All of the testimony about employment and whatnot was already argued on that day. There hasn't been a substantial change or any material change in the circumstances in the last 4 weeks. Ms. Mendonia's had multiple contacts with law enforcement, and each time there were trafficking amounts of narcotics involved, and she's currently has 2 cases of trafficking in narcotics. And based on that, the state would object, Your Honor.
Anything?
I'm sorry.
No, it's okay. I was going to say anything further, Mr. Nopes.
So the only thing I would just point out to the court, the 26 case number, I believe, really stems from something that happened back May of 2024. And then the 2025 case happened after the facts of the 2026 case. And I think from what I understand, the bond, if the court reinstated her bond on the 25 case, I think the bondsman, I don't see that they discharged themselves off the bond. They may very well just reinstate it without charging her a lot of money. And the problem is that she just can't afford $10,000 on the new case. And, you know, under the circumstances, since the facts of the 26 case happened 2 years ago, we'd ask the court to consider lowering the the 50,000 and the 50,000 on count 1 and count 2. She just can't afford that, Judge. That's in effect a no bond for her, and she had been out and not been involved with any other problems during the pendency until they brought the warrant from the 24 facts.
This is the exact same bond hearing that we had on February.
Right, and I reinstated the bond in the 25 case based upon the effect of the operative dates, right?
Correct.
All right, so in May of 24, the charges which give rise to the 2026 case, and it must be because of when the dates were, reading the addendum of probable cause, it appears that's when the testing was returned. That's what it appears. And so in May of 24, she was stopped and had trafficking amounts of fentanyl. Those charges did not arise until just now because of testing. And just a little less than a year after her arrest in May of 24, in April of 25, April the 24th, so just 14 days, I guess. 12 days before a year would expire. No, actually, it was 21. And she was stopped, and this time she was stopped, so it's a year after her first stop. This time she was stopped for 34 grams of meth, and if I'm counting this right, a little more than 10 grams of fentanyl. And so given the facts and circumstances, I restored her bond in the other case because it was unlawfully revoked based upon the operative date of the other charge. But I'm not going to reduce the bond in this case.
I understand, Your Honor.
All right, thank you very much.
Thank you, Judge.
You got some more, Mr.
No, sir, I think I'm done, unless you see something. Oh, I'm glad you said something, Judge. I do have one thing that I need to bring to the court's attention. It's not on the docket today.
Okay.
The other day when we pled, Devin Moore.
What's that case number so Madam Clerk can get up to speed here?
Sure, so she's got something to look at. She can see the minute sheet, 24 CF 327. That was the new law violation. And he had a number of VOP case numbers as well. in reviewing, when I got back to the office, there were 3 additional violation of probation case numbers that did not get added to the plea agreement. And so I just need to have a date that we can get him back in front of the court. No, it doesn't change anything because everything was agreed upon, but those cases appear to be remaining open because I did not get them added to the plea form.
Okay.
So is there a date?
When can you be here, Mr. Nopes?
I'm sorry?
When can you be here?
When can I be there?
Yeah.
I gotta be there at 12:30 for a pretrial detention hearing. Can we get him?
I don't know if we can get him here then or not, but if we can, we'll do it then.
That'd be great.
Are you saying this is a simple Scrivener's error?
Yes, sir.
Do we actually need the defendant here if the defendant believed he pled to all the cases and it's the same sentence?
No, sir.
State?
No, sir, it's going to be a credit for time served on all the VFPs anyways.
Yeah, what are the case numbers that were left off, Mr. Nopes?
2015 CF 1710, 2015 CF 1843, and 2015 CF 2775.
Okay. So, and the state stipulates that it was intended to cover all the cases and the sentences of the same.
That's correct, Your Honor, because if you recall, we had the new law violation in 24 CF 327. He was sentenced to 20 years in the Department of Corrections on that case. So we were just going to adjudicate guilty, revoke, and terminate in the supervision in probation for all the probation cases with credit for time served. And so the state would stipulate that the intent was that all of his VOPs would be adjudication of guilt, credit for time served, revoke, and terminate supervision. That was the intent. There were just so many cases. He had some different name spellings on different cases.
Right. I think at one point, one of them was spelled like this one is M-O-R-E, right?
Correct.
Right.
And
I think it was just we didn't catch all of the cases.
all right. So I think the way we'll handle this, Mr. Nopes, is you do an amended plea and sentencing agreement, and you specifically say on it that it's amended only for the purpose of adding the amended case numbers.
Good.
And I'm satisfied with that, if the state's satisfied with that.
State satisfied, Your Honor?
And then I don't see that the order's been done yet. So when the clerk does the order, that will dispose of all of the cases.
Thank you, Judge.
So Judge, so I understand what you're expecting of me. You're wanting me to basically pull back up the plea agreement that was used, add these 3 case numbers, or would you just prefer I do an order based upon stipulation?
That'd be easiest, wouldn't it? Do an order based upon the stipulation, adding the additional case numbers.
That's what I'll do, and I'll have all the case numbers listed on that, Judge.
Good deal. That's more
Thank you,
expedient.
Judge.
All right, excellent.
Have a great day.
Y'all too. Bye-bye.
Bye-bye.
All right. All right, some folks in the gallery. Ms. Yeski, do you have any? Mr. Cochran?
I do.
All right, you may proceed, ma'am.
I'm sorry, not in the gallery, in custody.
Okay, well, if there's anybody in the gallery, let's get them back about their business if they have. Anybody here have your own case today? Okay, and are you represented by counsel up here on the front row first? Do you have a lawyer?
Father, we're the ones who did the package. We put forward a expungement package package to you, sir.
Okay, what's your name?
Matthew Schlinger.
Okay, and that's 24 CF 1391. Come on down, please.
And just for the court's awareness, the Public Defender's Office represented Mr. Schlenker on the underlying case, but this is before the court today as a pro se motion for the
Right.
case expungement.
All right, does the state intend to traverse or demur the petition?
Not today, Your Honor, no, sir.
All right, so it's granted. If you'll submit an appropriate order, then the court will sign that.
And
Thank
my,
you, sir.
my office did have contact with the alleged victim in the case, and they had no objection as well, so.
All right, very good. Thank you very much.
Thank you.
Uh-huh.
Have a
Good
good day.
day. All right, and you have a lawyer, sir?
No, sir.
Okay, come on down. What's your name?
Harry Wheeler?
Wheeler.
Yes, sir.
Okay, and that looks like 21 CF 1668. And Mr. Gilbert's your lawyer, right? Or was, right?
Yes, sir.
All right, what
For
are we here for today, Mr.
for
Wheeler?
expungement, I filled out all the paperwork, I've done all the courses right at the beginning, paid all my fines, did everything the state attorney asked, and completed all the courses. I don't cause any trouble anyway, so it's
All right.
just,
Does the state intend to traverse or demur the petition?
No, sir.
Okay. All right, that means that it'll be granted, and if you'll submit an appropriate order, then I'll sign it.
what do you mean appropriate order?
An order granting the expungement.
So where do I do that at?
Well, the clerk has the orders on their webpage, and the law library upstairs can also help you find the appropriate order, and then you just submit it to my office,
Okay.
completed, and I'll sign that.
Yes, sir.
And that's required because the order then has to go to the clerk to close the file, has to go to the FDLE to seal the file, and so on, so that we have to use that separate order, and that's
All right.
your obligation.
Sounds great.
Okay?
Thank you
All
very
right.
much. Have a
Thank you
wonderful
very
day.
much. Good day. Thank you for getting it done. All right, anyone else here that doesn't have a lawyer? Yes, come on down. What's your name, please?
Tatiana Page.
Say again?
Tatiana Page.
Page?
Yes, sir.
Actually, Your Honor, the Public Defender's Office has been appointed in Ms. Page's new law violation. We just haven't been appointed yet in the violation of probation.
You are appointed in this case.
The new law violation for the clerk's awareness is 26 CF 392. We just, in the hopes of potentially resolving the case today, not to force it, like we're not trying to be forceful, but we did file information. That was just not too long ago, maybe 45 minutes ago, just once I saw that this was also on the docket. But I think I sent you, I sent you an email with it, it got kicked back.
Bless you.
Thank you. All right, so 2026 CF 392, is that right?
That's the new violation.
All right, and we have the 2024 CF 2202, which is the violation, correct?
Correct, Your Honor.
All right, and when is the 392 case set?
I believe it's April 16th, if I'm not mistaken.
Yes, arraignment April 16th, and then next week.
But you've already filed your
I just
information?
filed, once I saw that she had the new law case, I filed the information in hopes that if we could get a resolution.
Okay, so you do have an offer
Yes, Your Honor.
to resolve all of them?
Yes, Your Honor.
Okay.
It would just be to add 6 months of community control, a substance abuse evaluation, and a treatment recommended. That would make the new term date, just to be clear, January 16th of 2028. It was in June, I think, or July of 2027, just for the defense's awareness, she still has about $3,504.73 in restitution to Brett Crawford. I can't recall if we added this provision or not, but I would also add the provision that probation may terminate early upon the payment of that restitution.
And we've got a copy of the information, so we'll go ahead and do the arraignment so she doesn't have to be back on arraignment day, save everyone a trip.
Thank you.
Mr. Gomez, on the new case, would it be concurrent?
Yes, that would all be concurrent to be able to end.
Is that with an adjudication or without?
Yes, Your Honor.
Your Honor, if we could pass Ms. Page's case, and I could have a moment to speak with her, find out some more
Yeah,
information.
it's like we just turned on the fire hose and they're asking me to take a drink. So, yeah, we'll continue, let you have a chance to talk to her after one of your colleagues takes up. That way you can explain what's going on and she's going to understand. They're following my protocol to get the offer out as quickly as possible to resolve the case, and that's what they've done. So they're offering, and she'll take the time to explain to you how that would, and if you feel comfortable, then today, we can get all your cases done today and you won't have to be back in court. You only need to report to probation.
Okay.
But she'll take the time to answer all your questions.
Okay, awesome, thank you.
All right, so if you just wait for her, then we'll be back to you.
Yes, sir.
Thank you, Your Honor.
Okay. All right, anyone else in the gallery that doesn't have an attorney? All right, Mr. Cochran or Mr. McKinney, y'all have some folks that you can call quickly to resolve?
I'll defer to Mr. Cochran.
All right.
Your Honor, if I could have Mr. Boyd run out.
Boyd, please.
Yeah. That's 2020 CF 2803. Have one moment, Your Honor.
Yes, sir.
Your Honor, I have Mr. Boyd. We're going to ask to continue this. A part of this violation is restitution. We're trying to work some of that out.
Is that with the denial?
Yes, Your Honor, sorry, this would be a denial.
All right, and without subs?
Without subs, Your Honor.
How quickly? You want it 4/16?
416 is good, Your Honor.
State?
No objection, Your Honor. We've spoken about this case. A significant portion of restitution being paid would greatly aid the offer that we would give the defendant, Your Honor.
Okay. All right, very good.
Okay. Next, I have Mr. Eric McQueen, Your Honor. It's 2023 CF 2097. Your Honor, I'm asked to set this for the 423. We're close to a plea. We're just working out numbers. And by that day, it'll be ready.
All right, so,
It's going to be a DOD sentence, Your Honor.
so we're setting it on, this is a denial and then setting it without subs for a plea
Yes, Your Honor.
on 4/16 or 4/23?
423, Your Honor.
Okay. All right. Change of plea on 4/23.
Thank you, Your Honor.
Thank you.
Everybody. And then, Your Honor, I have Mr. Tyler Lunsford. He was here this morning. I've released him. It's case number 23 CF 1438.
Your Honor, at this time, based on the defendant's completion of a substantial amount of community service work towards the court cost, the state is going to dismiss the DOP and terminate supervision at this time, with the understanding that any outstanding court costs not covered by his community service work that he has done will be converted to a loan.
And I explained that to him this morning before he left, Your Honor.
All right.
That's all I have for the 9 a.m. docket, Your Honor.
All right.
And if we could recall Ms. Tatiana Page.
Yes.
At this time, because the current offer would have felony conviction implications, we would like some more time to consider the state's offer, and we will enter a denial for the violation of probation and a not guilty for the new law offense allegations and waive formal reading.
And we'll leave this set for the 511 and have them run together.
Okay,
Thank you, Judge.
great, thank you. Thank you so much.
Judge, this is Mr. Charles Keith before the court in 18 CF9. This is a felony violation of probation on her arraignment. We're going to enter a denial and ask for this to be set on the next available court date without subpoenas. I have been in discussions with the state. The state had tentatively made an offer of $11.29 Okaloosa County Jail to revoke and terminate. There's additional information that I'm getting from Mr. Keith's family. His wife is present in the courtroom to see if I can mitigate that situation.
State?
That's Mr. Snell's case, but this is a denial.
No objection.
All right, 416, no subs. If you have something sooner, you can bring it in anytime I'm present.
Thank you, Judge.
All right, thank you.
It's got to be underscore.
Judge, as Ms. Rosado approaches, may I approach with the state?
Granted. All right. And Ms. Dudley?
And I got Brenda Watson, 23 CF 2824. I have filed notice of appearance. I guess it didn't make it on the docket. I have spoken to Mr. Snell about it. If we can approach.
Granted.
Open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Home.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa.
Not cool, bro. I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday
All right.
10 to 3, and it's both our
Yes, sir.
Tammy Rothacher. Rothacher.
I do. Judge, Ms. Rothacher is before the court in 23 CF 1029. This is a felony violation of probation. I would ask the state to put the offer on the record so that she can hear that. We make a good record for that.
The offer, Your Honor, from the state is 36 months Department of Corrections, state prison.
And that would revoke and terminate it?
That would.
And Judge, I had previously filed a bond motion for Ms. Davidson Rothacher, and we'd continued that to today. So I believe that Ms. Rothacher is going to wish for me to move forward with the bond hearing at this time.
All right. You may proceed.
And Judge, may I ask a few questions of my client?
Yes, raise your right hand, please.
Yes, sir.
Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Put your hand down. Would you please state your name for the record?
Tammy Davidson Rothacher.
And you are on probation in this case number that I just announced, right?
Yes, sir.
If you were released on bond, where would you be living?
With my employer at 191 North Church Street, San Luis Beach, Florida.
And I listed your employer as Seaside Construction in the bond motion. Is that accurate?
They actually have a different name that they go by on everything, and it's Construction by the Sea.
What do you do with Construction by the Sea?
I'm a personal assistant to the owner, Sherry Dickerson, so a little bit of everything.
Are you currently a student at Pensacola State College?
Yes, I am.
And what are you pursuing at Pensacola State College?
Psychology. This is my last semester for my AA degree.
And currently, there's no bond that's set on the violation of probation.
Correct.
Do you think you'd be able to post a bond?
Yes.
What amount of bond do you think you'd be able to post?
About 1,000 cash or professional.
Nothing further from Ms. Rothacher.
State wish to inquire.
No, sir. No questions from the state.
All right.
And Judge, as far as argument, I do see that Ms. Rothacher does have, for the court's benefit, a misdemeanor case in 24 MM 3544. When I typed that into the clerk's side, I did not see that immediately pop up, which is why I bring it up. I know the court does its homework. That's reset on a misdemeanor violation of probation for the same reasons and with the next court date of April 6th. She does have a court appearance in Pensacola for one of the arrests that is the basis for the violation of probation. And then there is an FTA because she missed a court date in Walton County because she was incarcerated. So I wanted the court to have the benefit of all the moving pieces that I'm aware of when the court's making a decision in bond. This is the second violation of probation. It looks like the substantive terms originally were 3 years of probation. There's a termination date of March 13th, 2029. Originally, it was a $6,000 and change restitution amount. It looks like about half of that amount has been paid on the restitution. So I would defer to the court, but I would ask the court to exercise its discretion in setting the bond amount on the violation of probation 23 CF 1029.
State.
Your Honor, the state would object to a bond being established in the VOP. It's the state's position she's not entitled to a bond. While she's been out and on probation, she's committing new law violations across the First Circuit. as Mr. McKinney alluded to, she has 2 open cases, one in Escambia at this time and one in Walton County. The nature of this case here was where Ms. Rothacher rented a home and never paid a single dollar towards rent. And when she was asked for the rent or to leave, she proceeded to just take all of the contents in the home. It was a furnished home. She has, I had it pulled up on my phone, but she has similar situations, similar cases just like that all over Walton County and Okaloosa County. She has 7 CC cases, which all have to do with evictions because of not moving in and not intending to pay the rent in Okaloosa County. She has 4 in Walton County. This is it's basically a scheme that she's been running, and it's the state's position that she's going to continue to violate the law if she's allowed to be have her bond reinstated or established her own.
Any rebuttal, Mr. McKinney?
I would ask the court to view the facts as stated in the violation report when making the decision for bond.
I've reviewed the complete progress docket. I've looked at the history of violations. I've looked at the allegations in the violation report regarding this particular series of violations, and I'm just going to say it that way because it appears, depending on how you look at it, there's either 2 or 3 violations. And as well as the technical violation report, which the court received in October and directed that the department continue to supervise. Given the totality of the circumstances, the court declines to exercise its jurisdiction and will deny the bond motion.
Yes, Judge. May we hold Ms. Rothacher until the end of the docket so I may have a discussion with her on how we wish to proceed?
Yes, sir. Please hold Ms. Rothacher to the end of the docket for Mr. McKinney to chat with.
Okay. We will not need her back in court, though?
No.
Yes. We'll need her back in court.
Okay.
Frank, all the number 6, throw back and forth. Mr. McKinney, next we have Wysek, Lori Wysek.
Judge, Ms. Lori Wysek is before the court in 23 CF 2268. There was a report that was generated by the evaluator in this case. Has the court had the benefit of that report?
Yes.
I would note for the record that there is a misdemeanor case which is listed on the report that's not set in court today. And then there is a new law case from Crestview related to an incident at the jail. It is 26 CF 528. I've been in discussions with the state related to that case, which was an incident regarding a CO. And I did not want to delay the court's order any further than we need to here.
Is there information filed in that case?
Negative.
That would be a Crestview situs, right?
Yes.
All right.
Given the nature of the report, the defense would request the ability to file the report in that case number as well, and to include that on the court's order.
State?
No objection.
We understand what he's saying.
He's wanting to put this on the case that's being handled up in Crestview at this time, correct?
Correct. Right, he wants to include this report in 2026 CF 528, and the determination then would be binding on that case as well.
May we approach?
Granted.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family-owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us. Because we fight fire. Damn thing ain't working. Whoa!
Not cool, bro. I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
All right, thank you, Mr. McKinney. If you'll submit appropriate orders.
Yes, Judge, I'll submit orders in 23 CF 2268 and 26 CF 528 to the court.
Thank you. Yes.
We'll take them for first case next.
Thank you, Judge.
Svin, Perez with the interpreter.
And Madam Interpreter, if you raise your right hand, you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing.
I do.
Jason McKinney on behalf of Svin, Tele, Perez, total of 3 case numbers, 23 CF 489, 26 CF 192, and 26 CF 112. We have reached an agreement which handles all 3 case numbers. I did meet with Mr. Tele Perez at the Okaloosa County Jail with an interpreter and reviewed the agreement in full. The agreement was read to him by the interpreter. The signatures are from March 17th of 2026 for Mr. Tele Perez and myself. Mr. Tele Perez would be entering a plea of no contest as charged in all 3 case numbers. The agreement is for credit for all time served, concurrent between the 3 case numbers, standard court cost in each case, $350 cost of defense. In 23 CF 489, Count 2 is a misdemeanor DUI, which requires some standard conditions. So in that case and count alone, he would be placed on 1129 probation, supervised by JCS, with the standard $500 DUI fine. All standard DUI conditions. Those conditions include DUI school, 50 hours community service, 180-day DL suspension, victim impact panel, and a 10-day vehicle impound, per the statute. It is written in that entry of this plea shall result in being subject to deportation There is a current immigration hold. May I approach with the plea agreement?
Granted. Score sheet?
Do you have an extra copy? I expect the score sheet to reflect 41.1 points.
All right, so this would be a guideline sentence.
Yes, Judge. May I approach?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
You may put your hand down. With the help of the interpreter, were you able to understand what Mr. McKinney just announced to me?
Yes.
Did you read and sign the plea form with the help of the interpreter?
Yes.
Is what you read in the plea form what you just heard Mr. McKinney announce?
Yes.
How old are you?
24.
How much education do you have?
10th grade.
Do you understand by this plea agreement that you're pleading no contest to the announced charges?
Yes.
That tells me you believe that the state can prove your guilt and you're not going to contest that.
Yes.
Do you understand by making this plea, you're waiving your right to a trial where the state would have to prove your guilt?
Yes.
In this case, you'll be adjudicated guilty. Credit for time served. And on the DUI charge, it'll be 12 months of probation with the standard DUI conditions, including the school, the community service hours, the license suspension, the victim impact panel, and the vehicle impound.
Yes, that's fine.
Has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with how he's represented you?
Yes.
Court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you.
Thank you, Judge.
Awesome. We have Tracy Williams.
And Judge, what we're going to do in this is ask for a continuance and get her evaluated for the 90-day diversion program. I've been in discussions with Mr. Snell today about moving in that direction to see if we can work on getting Ms. Williams into the program. And that would probably have an impact with the state.
Okay.
I did see that there was an evaluator that had been appointed, and there was an evaluation that said that she is competent to proceed.
Okay.
So I'm going to ask for the next available court date without subpoenas. I'm going to have her evaluated for the 90-day program. If there's any change in that plan, then we'll ask to get back on the court's docket.
Okay. 416, no subs. State?
That's no objection to that, Your Honor.
All right, very good.
Looks like I took that.
Your Honor, next we have Matthew Spicer with Mr. Garrett.
Mr. Garrett.
Mr. Garrett, Matthew Spicer.
Good morning, Your Honor.
Good morning, Mr. Garrett.
Your Honor, Chris Garrett on behalf of Matthew Spicer, 25 CF 1612. Your Honor, we're here on a second motion to reinstate bond.
All right.
Did Your Honor have a chance to review the motion I filed in this case?
Yes, I did.
Thank you, Your Honor. And just kind of summarize, the alleged victim in this case, Stephanie Martin, did not appear at the deposition on February 9th, 2025. She does not appear to be present today. We are still waiting on some additional discovery in this case. There are two witnesses listed, Todd Neathawk and Corey Hale, that we do not have addresses for. I know the state is trying to track them down. And then, in addition, we are planning to depose Deputy Sullivan, but we anticipate that leading to additional deposition of potentially Sergeant Williams, the person who would have analyzed the air gun seized in this case. All of which is to say, Your Honor, that when we have this deposition on 4/13, he'll have been in custody for 116 days. It seems extremely likely as we sit here now that we're going to have to do a second round of depositions that'll be even further in the future. In the meantime, Your Honor, Mr. Spicer remains concerned about his property. He believes property is being stolen from him, including a dirt bike, things of that nature.
And he's back over $8,000 worth.
And we just ask Your Honor to reinstate his bond with.
The sheriff's department told us sister when she called them that they wouldn't do anything till August. They wouldn't move forward in the case until I was released from prison. They said they had to be back out so they could do anything.
And Your Honor, just based on all of that, we'd ask that Your Honor reinstate his bond with any conditions deemed necessary by the court.
This is another case where we've had this exact bond hearing, and it was explained at that time that there is no outstanding discovery. There is not any additional discovery owed to the defense as far as a pellet gun. That's all of the information that they have, and it's on video. And plus, the defendant takes them to the pellet gun, and it's listed in the offense report. So I don't know what additional information, there's not any out there. Just like when we were here before, it was explained that the alleged victim was not available on that day due to hospitalization. That's a reasonable explanation for an absence. She's been in my office every week, and there's two witnesses that were listed by the state that have changed addresses. They moved down the street. So that's not going to be a difficult piece of information to get to Mr. Garrett. So the state, I guess, to sum it up, it wouldn't object to any modification or establishment of a bond, Your Honor. This happened to the victim on August the 5th when she was hit in the head in the face, right in the forehead, with a pellet gun that looks like a real gun. It's a metal gun smashed in her forehead. That happened on the 5th. Then on the 18th of that month, she was hit with massager, a handheld massage gun on the side of her face right there that caused a huge laceration and a black eye. And this defendant made her clean it up, said you're making a mess on the carpet and clean up your own blood. And just for the safety of this victim, the state would vehemently object to a bond being established, Your Honor. And anyway, she's going to be there at the deposition, your officer's going to be there, and we'll go and find these two witnesses in the address and make sure they're there. So that's the state's position.
All right, so as I understand it, the defendant was out on bond in one case and then was arrested on the subsequent cases, correct?
Yes, Your Honor.
And the subsequent cases were the basis of the revocation of the bond in the, I think it's 25 CF 2162, correct?
I don't know that case number, Your Honor, but I'm not on the second case. The public defender is appointed. But yes, Your Honor, that'd be the gist. However, the state did not object to, had the opportunity to do a pretrial detention, did not object to a bond on the new cases. So.
Understood. Any further argument? Ms. Yeske, you've risen because the court was addressing the case in which you represent the defendant. Do you wish to be heard in any way?
No, just to clarify that the Public Defender's Office represents Mr. Spicer in 25 CF 2162 and 2163, where there are cash and professional bonds in place.
And Your Honor, can I add one more detail about the pellet gun?
Okay.
Your Honor, basically, but what I'm looking for in discovery is any indication that it was analyzed for blood, fingerprints, DNA, anything like that. What we have on the video is it is taken from a shed, placed in a paper bag, and then there doesn't appear to be any additional information about it in discovery. So.
Anything further?
No.
Okay. 903-0471. A court may, on its own motion, revoke pretrial release and order pretrial detention if the court finds probable cause to believe the defendant committed a new crime while on pretrial release or violated any other condition of pretrial release in a material respect. The court declines to exercise its discretion and grant the motion.
Understood, Your Honor. I believe he's already set for pretrial.
Yeah, he's set on 5/11.
5/11. Yes, Your Honor.
All right, thank you.
Thank you, Your Honor. Yeah. Have a good day, Your Honor.
Yeah, Robert.
Yeah, as well.
Judge, this is Mr. Robert Wilcox before the court. He has 26 CF 471. This is actually an arraignment. It was placed on the day's docket after we transferred it down from Crestview to match his other case, which is 25 CF 1033. My understanding is the state has filed an information in 26 CF 471. Do you have that, Madam Clerk?
So the 25 CF case is what?
Yes, that's already on 511 for pretrial in 25 CF 1033.
Please. This is Mr. Wilcox.
Correct.
Yes, we filed that information, Your Honor. I did.
All right, so not guilty, and we'll leave this to run with the,
Yes.
so 471 and 1033 will travel together on 511.
Yes, Judge.
All right, very good, thank you.
We have Ms. Sarah Rector with Ms. Jensen. Richard.
Your Honor, this is Sarah Reacher before the court in 24 CF 1424. This case was set as a status because she's back from Florida State Hospital.
Right. I've reviewed the report. Does the state accept the report?
Yes, sir.
All right. So the court, any further argument in that regard?
Your Honor, we are working with the state to come to an appropriate resolution in this case based on the new findings in the report, and we would ask for it to be set to the next available court date.
All right, we'll set it on 511. Then if you reach an agreement sooner, then you can bring it in for the plea sooner.
Thank you.
All right, thank you. And the court will make the determination that the defendant is able to proceed at this time.
And that's the plan, is to bring her back well before that date, Your Honor, the 511 date. So I believe that will be accomplished.
And if you'll submit an appropriate order on the competency, please.
We have Wendy Spears with Ms. Jensen.
This is Ms. Spear before the court in 25 CF 194. If I could just have a brief moment.
Yes, ma'am.
Your Honor, Ms. Spears indicated she is interested in the state's offer at this time. And so if we could pass her, I can write up the VOP agreement, and then that will give Mr. Snell also a chance to get us a score sheet.
All right, very good.
Thank you.
Spear for a pleas.
Now, State, I also saw Samuel Rascon with Mr. Switek on the docket. Is that to be on today? Are you aware?
Mr. Switek filed a motion to continue, and I know that his assistant has been in communication with Ms. Natali about canceling the hearing for today.
Are you in agreement?
I am, yes, Your Honor.
All right, it's continued. It'll be removed from the docket.
And I believe it should be set for next pretrial on 5/11.
I would have to look at the, but we'll make sure that that's the situation, 5/11.
Thank you.
Next, we have Henry Reeves, Ms. Jeske. Reeves.
This is Henry Reeves before the court in 20 CF 2227. We're here on a violation of probation allegation.
Is that Mr. Reeves?
Yes, Mr. Reeves.
What's your question?
Is there
Given the nature of the violation, which was accessing the internet, the offer from the state would be to revoke and terminate and DOC. He currently scores a minimum of 44.4 months DOC.
So the state's offering a guideline sentence?
No, Your Honor, not yet, because I'm not sure if he has served any amount of time in prison. If he hasn't, that would be the offer. The guidelines. If defense can advise whether or not, because I cannot access it readily.
If I could have a moment
Yes.
to do so. For that time.
Yes, ma'am.
At this time, we will just enter a denial of the violation so I can have more time to meet with Mr. Reeves and get it set to the next court date.
Okay, we'll set it without subpoenas at this time.
Okay, thank you.
416, no subs.
Thank you.
All right, thank you very much.
Robinson?
Your Honor, this is Reggiana Robinson before the court in 25 CF 2150. This case is set to be heard on a bond motion today, which was written by Mr. Koch.
Yes.
This is Reggiana Robinson with Mr. Snell. Does the court have access to the bond motion?
I
Otherwise, I
do.
have a copy. I would just like to highlight a few points in the motion. And I know a previous motion has been heard, but we believe that the circumstances have changed since the last hearing, as Mr. Robinson's cancer has been progressing. Along with the motion, you've been provided with a letter from the medical director with the Okaloosa County Department of Corrections, Mr. Delgado. This discusses the significant, special, ongoing, off-site oncology treatment that Mr. Robinson's condition requires. This also includes services with off-site medical monitoring, and as the Department of Corrections Administration has put it, they are able to provide these off-site appointments. However, it is coming at a significant resources. Basically, they're averaging about $3,800 a month for treatment, and then around $25,000 for each of the 21-day treatment courses that is required to maintain the multiple myeloma cancer that Mr. Robinson is battling at this time. In addition, being incarcerated does put him at, because of the severe immunosuppression that he currently is battling, incarceration puts him at an increased risk for life-threatening infections as well. And I do have a copy of the letter from Mr. Delgado, the medical director, if the court would like.
No, ma'am,
Okay.
I have access to that.
And then ultimately, Your Honor, we would just be requesting a $35,000 signature bond and to impose pretrial services, which would include weekly by phone reporting, a GPS monitor attached prior to release, not to possess firearms, weapons, or other destructive devices, have no contact with the alleged victim, not to be within 500 feet of the alleged victim, the victim's vehicle, residence, or place of employment. And that is outlined in the motion as well.
Your Honor, the state's position hasn't changed. Mr. Robinson told the alleged victim, that he intended to kill her and put knives on her pillow and told her to be ready. And based on that and the safety of the victim, the state believes that the best situation to protect her is for the bond to remain as no bond.
All right. Anything else, Ms. Yesky?
Your Honor, just that we believe with the progression of his condition that a signature bond with the enhanced GPS monitoring and pretrial services would be sufficient to ensure the safety of the community and the alleged victim, as well as ensure that Mr. Robinson is able to make appointments and come back to court.
The court's not insensitive to the defendant's medical condition nor to the cost to the citizens of providing for that. The court, however, is looking at the overall situation here and the escalating pattern of behavior demonstrated by the defendant over time. Looking only at the risk assessment and the first appearance paperwork, the defendant has 10 failures to appear, 2 violent felonies, 7 possession charges, 3 possession with the intent to sell, 2 violent misdemeanors, 17 other misdemeanors, and 6 other felonies. The court does not believe that the reduction in the bond represents a reasonable disposition, notwithstanding the other factors. The motion is denied.
Thank you, Your Honor.
think Rothacher is ready to go.
All right, Rothacher, please.
Judge, may I have just a moment at the podium?
Yes.
This is Tammy Davidson Rothacher before the court in 23 CF 1029. This is felony violation of probation. The court's heard a discussion today about that at a bond hearing. I've had further discussions with my client. She wishes to admit to the violation of probation in 23 CF 1029. This would be a plea to the bench. We would be asking for court to be set off for the sentencing at the soonest available date on the next available miscellaneous date in the afternoon. May I approach with the plea agreement?
Granted. Do we have a score sheet? What does the score sheet show?
It'll be 28 to 30 points with the
community sanction points.
All right, so eligible for state prison sentence, but not a presumptive sentence?
Correct, yes, sir.
Okay.
And that's the anticipation of the defense as well. I was looking to see if there was an old score sheet.
I didn't see one.
And I didn't see one, but given that this is a withhold and a grand theft, I do not anticipate that it's going to be over 44 points.
All right. Raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right, you can put your hand down. You heard what Mr. McKinney said? And you signed the written plea form?
Yes, sir.
You understand that you're pleading, that you're admitting the violation? All right. And by doing that, I understand you to say you agree that you violated your probation the way the affidavit report says you did. No, that's okay. That's the reason we do this. My job is to determine if your decision is free and voluntary. It can only be free and voluntary if you know and understand what you're doing and all your questions are answered. So that's the reason I ask them. So is that what you're telling me, that you agree that you violated your probation the way the affidavit report says you did?
Yes, Your Honor.
Do you understand by doing this, you're waiving your right to a hearing where the state would have to prove that you violated?
I do.
In this case, there's no agreement regarding your sentence. Do you understand what that means?
These and there would be a sentence imposed by the judge at a sentencing hearing.
It's at the court's discretion, correct?
Right, it's completely up to me. And the reason I ask what the score sheet shows is you're more than 22 points, which means you are eligible for a prison sentence. You're less than 44, which means it doesn't presume that the court must impose a prison sentence. But I like, of course, it's not humorous at all to you because you're facing prison potentially. But I like to give a stupid illustration. You know, I'm on my way to work, somebody cuts me off in traffic, I spill coffee on the new tie my daughter gave me, and I'm just mad. I can take it out on you and put you in prison for 5 years. It wouldn't be the right thing to do, but it would be absolutely legal because you're making an open plea to the court. It's completely up to me. Do you understand that?
I do, Your Honor.
All right. Does that change your willingness to enter into this plea arrangement?
No.
All right. Now, has Mr. McKinney's told me that he wants a separate date for a sentencing hearing where, with his help, you're going to present to me what you believe I need to know so that I can make a good and proper sentence in this case. Do you understand that?
I do.
And so he'll have the opportunity to do that and convince me what a proper sentence is in this case.
I do.
Has he answered all your questions about the plea and how it affects you?
Yes, sir.
And are you satisfied with what he's done for you at this time?
Yes, sir.
All right. And Mr. Snell, I need your signature here. Now, the one last thing is, you understand although you're pleading to this doesn't dispose of your other cases that are outstanding.
Yes, sir.
Okay.
I just ask that I'm able to be in attendance at those cases so I can defend myself.
Yes, ma'am. I don't see any reason why that would be any impact with what we do here.
Thank you.
All right.
And on that note, since it was brought up, I did tell her that I would reach out to my counterpart in Walton County to see if they would file a motion to transport for her to resolve the matter in Walton County, as long as it does not impact our court date here.
All right. Is 4/16 going to be too quick?
No, Judge.
All right, 4/16 at 2 p.m. and we'll do sentencing. PSI waived, Mr. McKinney?
Yes.
What's that mean?
Pre-sentence.
Thank you, Madam Clerk. All right, thank you, Dan.
Thank you.
Your Honor, we have 130 cases here. Redmond, or Otis Redmond? I believe this is with no attorney assigned.
All right. We have information.
Your Honor, the state did not file an information on this case. So the state isn't going to move forward on the false name charge. Mr. Redmond has signed the waiver for Georgia and for Texas. So Georgia has until April 3rd to pick him up, and if they don't arrive at that time, the jail will be notifying Texas, and then they'll have 30 days from that date to pick him up. And so
So what we should do then is we should set this for a status date to be certain that that's resolved, and I'm going to appoint the public defender because he's being held on a warrant for extradition, and I don't want him to be lost in the system without representation, and you'll be appointed provisionally. We'll set this for a status date. Do you think the 4/23, that's about 30 days, and if something happens sooner, then we can take care of it, and I want him back here so that Ms. Yeski has access to him to be certain that the case moves.
That would be fine.
All right. So Madam Clerk will set this case for status only, and we'll set it on our arraignment docket. I think that's the best thing considering the situation. Okay?
Thank you, Your Honor.
All right.
And that was 4/23, correct?
Yes.
Okay.
Yes.
All right. Who we got next?
I think we got Spear. I'm just waiting on the booking deputy to get back over there. Send Spear through.
And then I just got a note from Miss Natali, the PTD at 4:30 on Jean Zunin. After reviewing that, that appears it should be a Fort Walton status, so the clerk has moved that to Fort Walton Beach.
Yes, Your Honor.
Okay.
I was made aware, thank you.
Okay.
Ms. Spear?
This is Ms. Spear again before the court in 25 CF 194. Okay. She has read the agreement, and I'm just going to have her sign it now.
Yes, ma'am.
Right there. And I'll announce the terms as well. This will be an admission to the violation of probation, adjudication of guilt, revoke and term probation, 90 days in the Okaloosa County Jail with credit for time served from February 22nd of 2026, which is the date of this violation of probation arrest. She will be willing to waive all prior credit prior to February 22nd, 2026, waive non-monetary requirements, send monetary requirements to collections. There'd be a $50 VOP fee, $50 cost of prosecution, and a $150 cost of defense.
Granted. Okay. All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes.
All right, you can put your hand down. You heard what Ms. Yeske said on your behalf, and you signed the written plea form?
Mm-hmm.
Is that yes?
Yes.
Do you understand that you're admitting the violation?
Yes.
And that tells me you agree that you violated the way the affidavit report says you did. Is that yes? Okay. I'm sorry, I see a nodding and smiling. I understood, but we're making a recording, and if the record needs to be clear that you're saying yes, I apologize. And do you understand by making this plea, you're waiving your right to a hearing where the state would have to prove your violation? And in this case, you'll be adjudicated guilty, if not previously. Your probation will be revoked and terminated. Your cost will be, it's going to be $100 cost of prosecution. Although it's a misdemeanor, it's in felony court, so it's $100 cost of prosecution.
Okay, thank you.
And it's also $100 on the other side as well.
Okay.
All right. And you'll be sentenced to 90 days in the county jail with the credit from your arrest on this time, and you're waiving your prior credit. That's important because ordinarily everyone's entitled to all the credit they've been given. But by waiving it, I understand that's the reason the state offered the 90 days as opposed to a different sentence. Do you understand?
Yes.
Okay. And has Ms. Yeske answered all your questions about the plea and how it affects you?
Yes.
Satisfied what she's done for you? Good. Is that yes?
Yes.
The court will find the plea to be freely and voluntarily entered into and will accept the plea. Now, we can send all your monetary obligations to collections. That may have other consequences for you. I can give you 2 years to pay if you'd prefer to do that and try to get them paid off before they go to collections.
Yes.
Okay.
Thank you, Your Honor.
All right, thank you. Please freely and voluntarily entered into and accepted.
Come on back this way, Ms. Spear. We have Nicholas Burrows from the 130 docket.
Nicholas.
Your Honor, this is going to be a plea. I just finished typing up the agreement.
So you need a minute?
Yes, Your Honor.
Okay.
I just got to go print it off. Yep.
can I ask for your assistance on a case number? 26 CF 520. To see if it's set before Bolton. Is it set before Bolton?
Oh, it's me.
Your Honor, we have Mr. Nicholas Rose, case number 26 CF 0373. Today, my client's going to be entering a plea. In exchange for a plea of no contest, the state has agreed to an adjudication, 2 years of probation, early term at the completion of all conditions, and those conditions will be 24 hours community service, a shoplifter's awareness course, and $979.97 in restitution to Target. no return to any target. Standard court costs, 150 public defender fee. I have the signed plea form and the score sheet, if I may approach, Your Honor.
Granted. Is that the state's agreement?
It is, Your Honor.
All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
All right, put your hand down. You're, Mr. Cochran said you signed the written plea form.
Yes, sir.
How old are you?
How old am I?
Yeah, 40. How much school do you have?
I have a GED.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And it's what you've read in the plea form, what Mr. Cochran just announced to me?
Correct.
In this case, do you understand that you're pleading no contest to the announced charges?
Yes, sir.
That tells me you believe the state could prove your guilt to the jury and you're not going to contest that.
Correct.
Do you understand by making this plea, you're waiving your right to that trial by jury where the state would have to prove your guilt?
Yes, sir.
In this case, you'll be adjudicated guilty. You're going to be on 2 years of probation with an early term. If you get all the conditions completed and you have no violations, 24 hours community service, shop literature class, the restitution. You can't go back to Target, any Target, plus your court costs and fees. And how much are those court costs, Madam Clerk? All right. Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with what he's done for you?
Yes.
The court will find the pleas freely and voluntarily entered into and accept the plea. Thank you. With the adjudication.
That's right. And for the record, Your Honor, he does have a hold out of state. I've advised probation, so we would ask for 48 hours from his release from the out-of-state facility to check in for probation.
All right.
And probation, I've made probation aware of that issue.
All right, very good.
Thank you, Your Honor.
I think that's all I have, other than the pretrial detention.
All right. Anything else we can take care of before we take a recess for our pretrial detentions?
I make a mistake.
All right, and I think Court TV is going to be here for pretrial detention, so I think the state probably needs to discuss with them the one case during the recess so that they'll be aware of what's going on, okay?
Yes, Your Honor.
And the statutory provisions.
Yes, Your Honor,
All
thank you.
right, we'll be in recess then for our